Hello, hello, hello. Oh, she did answer. Okay. Great, great. I think I know what tomorrow's live's going to be. Hello, hello. Update on Garcia. Okay. Yeah, today was a big day. Today was a big day. But welcome in, everybody. Welcome on in. She has no ethics. True story. Yeah, that's right. I think the charges against him are bogus. Well, that could very well be. Actually, that could very, very well be. We're going to have to see how everything unfolds. The thing about the criminal justice system, though, that I have to say is, you know, the process itself will eventually get to the truth. The tea is piping hot, yes. Yes, indeed. Hello, Willie B. Welcome, welcome, welcome. Trying to make sure I can see everybody's SCOTUS rulings today. Oh, yes. So, Brandon, I tell you what, I have got a super post coming up on the U.S. Supreme Court case decisions. I think the big one that hit the media was the Doge Social Security one. So that was like the shadow docket case. So that was a kind of a big whoop-de-whoop for sure. Oh, thank you very much, Sylvia. Thank you. Hi, John. Welcome. Do you need popcorn for this one? Well, I don't know. I mean, I've had a lot of popcorn yesterday. But I think it's always a good idea to have popcorn. Always, always, always a good idea. Yes, happy Friday. I'm so glad it's Friday. This week's been bonkers. Absolutely bonkers. Hello, Swish. Thank you for your patient hard work. Oh, of course. I'm happy to be here. Yeah, what's happening in the Supreme Court? Great question. I don't know. I don't know. Right now, they're basically just kicking opinions out like there's no tomorrow because they want to have all of the decisions out before, July 1st so that they can all go on summer vacation, which I put in quotes because, there's not going to be much of a vacation for them because of all of this rubbish that's been in the courts recently. So there's going to be a lot of that. Can they subpoena the prosecutor that quit? Sure, you can. Now, my understanding, again, everyone, with the situation in Tennessee, I need more information. I want more information before we fully go forward. But impeach the AG. Well, yeah. So I would say, again, and I've said this a few times, if you have a situation in the Department of Justice or in any, office where you have attorneys who've sworn an oath to the Constitution, there are moments in our careers where we have to decide what's more important, following orders or following our oath to the Constitution. So a lot of attorneys are really having that moment right now. And this isn't a good time to have to, say, go home and be like, oh my gosh, I lost my job because, I've got ethics. So it sucks. It absolutely sucks. But it also shows a level of integrity that, we just don't see in other fields, because you are intentionally coming in and saying that there's something so much more important than, the walking up the ladder situation for work, something so much more important that you have to walk away from it. And it could be your dream job. A lot of times the DOJ positions are dream jobs for people, and you have to walk away because they're asking you to violate your own integrity. Yes. They're housewives of DC. These are grown men. Oh no, I mean, who's saying that? Because there are, I hope nobody, who's saying that? Are you kidding me? I've always looked at it both ways. There's housewives, house husbands, house people, whatever. And whatever it is, it's an important job. When you're at home trying to take care of home stuff for whomever's going out constantly. So, yeah, that's definitely... Are you freaking... Yeah, if you're talking about anybody in Congress whose spouse is at home, like yowzers. That's like a tough job. Absolutely. Absolutely. So welcome in, everybody. Welcome. Welcome. We have here first two were dismissed. All right. Well, you kind of knock them up and set them down. This complaint is signed by quite a few people. I've not seen the other two complaints. I took a look. I know there was one a few years ago, actually. I can't remember what year it was, but that got some traction. I don't know what the final outcome was because, she's still practicing. So obviously whatever it wasn't too dramatic. I didn't understand why they resigned. Oh, yeah. I mean, yeah, you have to. You have to make the choice, and it sucks. I from experience, I know the choice, and it's a difficult choice because you wind up having to uproot your family if you've got a family. Everything that you've been working for. You have to say goodbye, and it's not really a good goodbye either. It's really awful because you're basically saying, I have to leave because you're asking me to do something illegal and unethical. And I'm not going to do that. And bosses don't like to hear that. They really don't. They really don't. They get upset about that. But sometimes, you got to do it. All right, here we go. Let's dive in. We've got the Florida bar here. This is an ethics complaint against the Bondi here. And let's take a look and see who filed it. We've got Creative Criminal Defense Consultants, which, that's a great name. If nothing else, this is an amazing name. I think we should all acknowledge that here. Is there a complaint from the American Bar Association? That I don't know. I do not know of that yet. I've not seen I think there is, I'm not sure if they filed an ethics complaint, but they filed something somewhere. I don't know if they've just published it or not, where they have expressed concerns about her. But I don't think it went all the way to an ethics complaint. It's more one of those like, well, what's your thoughts on this, ABA? And they're like, well, we don't care for this, this, and this. So you can kind of hunt around and look for that. But how is that viewed by other attorneys? Which, what do you mean, like having complaints or walking away for ethics? You have to clarify. Okay, I've got my eyes zoomed in on the chat. Is it the ethics or is it the filing against you or the walking away? Which one here? Looking at the chat. When you resign. Okay. So how do other attorneys? That's a good question. And, I think the walking away. Okay. It depends. I think, there are definitely some cliques in the legal world when it comes to attorneys. There are a lot of cliques, and there are some areas of the law practice that are like completely populated by men versus overwhelmingly by women. I mean, there's still areas that are designated that way just because that's how the numbers fall. There are some categories or some areas of law that are just, certain kinds of attorneys take those kinds of jobs and that's situation. So we have cliques within the legal community. And, there's two primary roads that I've seen. And I've always called it this way. You're either in it for the money or you're in it for the love of the game. And, if you are part of the, I'm not here to make a lot of money. I'm here to do what's right and to, protect the Constitution. That entire wave of attorneys is like, good for you. That's amazing. That's how it's supposed to be. Good. You got to walk away. You had no choice. Meanwhile, the ones that are in it for the money are, the Ivy Leaguers, the ivory tower, people are just like, what's the problem? That sounds like a you problem. So it can go either way. And that's how you can figure out, who you want to associate with and what kind of a lawyer you want to be. Do you want to be the one that's like, I'm in it to win it. I'm after the, Top Gun award or whatever, like, you know, there's no place for second place on the plaque or whatever. Like, those are your people. Good for you. Off you go. Those are not my people. My people are the ones that are like, you know, I want to know, you know, what happened here, and I want to let you know I support you and your choices. So it can be, it's a split circuit, I would say, on how we go about it. Oh yes, thank you so much. I've got a whole bunch, everybody, of pride nails. So get ready for some serious rainbow action this month. I've been waiting. I've been collecting it for the last few months. I'm like, we got to have extra rainbows this year. So these are my my rainbow nails. Extradition process. What standing does that give to the DOJ with the court issues? Do you mean like the contempt issues because they weren't following orders? Is that what you're meaning? What's standing with the court issues? Oh, thank you so much, Dale. Oh, thanks. Yeah, is that okay? So I think it's important to remember here that you know, you can do stuff that you're ordered to do and still get into serious trouble for stuff you already did. And the contempt issues that had been going on in the JGG slash Sanchez case with the people that were taken over to El Salvador, that contempt issue is still in place. I mean, of course, they're still in El Salvador and getting that sorted out. But here, you know, we've got lots of issues in play, and you know, there were multiple times, and actually there's been a request to file a motion for sanctions. I'm not sure if that motion's been filed or not. That's still valid. All of the times when deadlines were missed, when answers weren't given, when there was clear bad faith, each and every single one of those times can still be accounted for. You know, I don't see the fact that Garcia's back in the States. That's not a win for anybody. That's not a like, all right, good job. No, that's not a win. That's like bare minimum so these attorneys don't go to jail. That's kind of what this is. So there's still possibilities for tons of contempt. There's so much bad faith that's been going on in the Garcia case and in the other cases that I would say he's back. That's great for him and his rights. And it also shows anyone else that's over there this is possible. So they can use that in the other cases to say, well, the government brought, him back. So why can't he bring the others back? So I think that's helpful too. But as far as them getting some kind of credit, no, there's no credit here. Right. Exactly. Yeah, I mean, that's just who it is, right? Yeah. So, but it's a mess. It's an absolute mess here. The Abrego Garcia situation. Who controls the Florida Ethical Bar? All right. So what all of our bars do, let me just give you a quick, overview of how our ethics work. We have, my ring light. Ooh, powerful. We've got model rules of professional conduct out of the American Bar Association, and there's a Center for Professional Responsibility that gives us the guide for all of the states in order to determine what would be the best, rules. And so each state has its own way of setting out the license process for attorneys, right? So in order to practice in the state, you have to be licensed in the state, and then there are rules for that. And then you have to maintain a level of professional responsibility, and that's our ethics. And so that's also maintained. All of these things go through the highest court in the state. Those rules are regulated through the legislature as well as through the judiciary. So whomever's in charge of the ethics, in charge of enforcing the ethics rules, that's like a full-time job. So it's possible that they're a branch off of a particular, let me explain it like this. My own ethics bar people are their own unit inside of my judiciary, right? So we file with the professional, conduct people. We have to file with them each year to make sure we've got credits, because we have to get ethics updated every year. And then we also file in with the Supreme Court, and those go to the same place, right? So there's like within the courts, there is the lawyer's responsibility ethics piece of it. So it's not something where people are elected. These are full-time jobs. I suppose, you can nominate people, or you can write letters of recommendations in, but then it's a fully run department. It's not it's going to be a mixed bag. It doesn't matter which party's in control. It truly doesn't, because it only matters who's got the best qualifications, right? Because it can be tough to be in that role, because if you're the lawyer that goes out and tries to make all the other lawyers behave, or pull their license, or give them sanctions, or shut down their law firms, if that's your job, a lot of people aren't going to like you. So, you walk a fine line as being the one to enforce the ethics rules. So you got to be careful with that. But no, it's not a political situation. It's just another piece of the process of getting your license and being allowed to practice. And again, every state's going to have it set up a little bit differently. Every state has its own ethics department. All right. So there's going to be one body that gives you your license, and then there's going to be another body that watches your ethics, and those can cross over, but those are two roads to go down. All right. Does that make sense? Yes, thank you. Right. So that's what we're talking about. Now, when we've been going through our ethics discussions, I've been talking about the DC bar, because usually the AG's office fighting for a lot of these cases are filed in DC, and they need to be licensed. But with the federal system, things work a little bit differently. So, for example, we have, oh my gosh, what's her name? Sydney the Kraken. So Sydney Powell, for example, licensed in Texas, all right, but can work at the federal level. And Ellis here, she was licensed in Colorado, so that's where you would go in order to file ethics against her. Giuliani licensed in DC and New York, so both of those places. Eastman licensed out of California, and I'm not sure if he was in DC or not. I want to say he was, but his license was pulled in California. And then, the filter, sorry everybody. Who else? Jeffrey Clark, his license was, okay, wait, let me think. Where was he licensed out of? I think he might have just been DC, actually. I'm not sure. This is not attorney. Okay, and Cheesebro, I think he was licensed in Wisconsin and in DC. So the key is you've just got to find wherever they're licensed, and that should be, oh my gosh, the filter, everybody. Oh my gosh, I can't, oh my goodness. I tried to take the filter off, but then every time I showed the prosecutors, people were like, where's the filter? Sorry about that. Sorry, everybody. Sorry, not sorry. The point is, the bottom line here is you have to go to wherever they're licensed to go after their license. So a lot of people are licensed out of DC, so that can be a very good place to start. All right, but so we've got New York, California, Colorado, Texas, Wisconsin over here. I'm not sure about Clark again. I know DC, but I'm not sure where else. And for Bondi, and I believe too, the lead fella in a lot of the immigration lawsuits, he is also out of Florida. So you just can pull up their name and then see where they're licensed out of. You got to kind of hunt it down. That was how I figured out Stephen Miller wasn't an attorney, because I'm like, whoa, I need to file some ethics complaints against that fella. And so I was like, where's he licensed out of? And I'm like, oh, I can't find it. Well, he's not a lawyer. So, no, couldn't find an ethics complaint in that situation. Okay, is it just DC? Okay, that makes sense. That's what I thought. Yeah. So The Pam Bondi here is in Florida, and we've got a complaint filed against her. Now, if you file a complaint, you got to fill out this form and send in your evidence and make your arguments. And there's a whole process, and then they'll take a look at it. They'll read through it, the committee, the professional responsibility people, and they'll see if it, has enough points to it where they go forward and investigate. If there's an investigation that's appropriate, then you go forward, you investigate it, and then come back in, make your decision, and then explain it to the group, and then the group decides. Like for Eastman, he had a big old trial. Basically, it was actually so much information came out on the bad behavior on January 20th of what those things actually, what some of the problems were, some of the actual facts of that situation. The facts that came out during his license hearing can be used and hopefully will be used in the Georgia RICO case, because that evidence came in those kinds of administrative proceedings for Mr. Eastman out in California. And that information then can be used again, of course, because it's, under oath in a legal proceeding. All right, so that's kind of how that goes. Is her brother in charge of the committee? So it looked like he was, I think, was it? I don't know. Was supposed to be nominated to be in charge of the DC Bar Association, I think. Now, the thing is with the Bar Association, that's great. American Bar Association, they give us these rules, and that's great. But, they're also just a group of old people that have been lawyers for a really long time, and they just sit around and have cheeseburgers and Diet Cokes once a week and talk about the good old days. Let's be real. When it comes to bar associations, those are voluntary organizations. Now, to have your license with the state, that we call that something a bit different, even though we refer to it as a bar. All right. So there's a couple of different roads. The state that you're getting licensed out of, you're licensed through your legal system, through your system, your legislative system there, right? Like for me, it was my state Supreme Court that wrote out my license. Meanwhile, there's an association you can join for different areas of your state and other states. Now, this association, the American Bar Association, is just this kind of big bar association where, again, the dinosaurs hang out. It's like, the Lost World where all the old dinosaurs are hanging out and getting sun and stuff. And then some of the youngins will come in and try to explain computers and stuff. And some will be like, okay, that's cool. And some will be like, no, I'm not doing anything. So what I'm trying to tell you is that it's important, and the American Bar Association gives a lot of great information. And don't come for me, ABA, but I'm right. But also, it's not like it's some kind of, Harvard Law Review situation. All right. It's not. It's a group of an incredibly seasoned attorneys talking about, what's what in the legal world. All right. So let me clarify that when I'm talking about an association. So here, when they're talking about the Florida Bar, they're talking about where you got your license from. So when you're filing an ethics complaint, it goes through that. Can ordinary citizens file a class action lawsuit against lawless elected appointed officials? That's a lot. Right. So in order to file a class action, you have to have some kind of harm, right, that was done against the law, right, or some kind of violation of a duty. So if you have some kind of intentional harm, that would be an intentional tort, or some kind of negligence, those kinds of things, or there's some kind of statute that they have violated, I think one in the RICO case that I always liked, which was actually pulled out of the indictment, was the violation of their oath of office. So that's a good one. And it's tough because for the class, you have to set out a set of factors that everybody falls into as well. So not easy, but can be done. Right. Yeah, I don't know about that. Terrible things to jump on. Oh, yeah. I mean, you're not going to... Class actions, class actions are lawsuits. Can PTSD be considered that because they're causing me all kinds of... Oh, my gosh, Amber, that's so funny. but a lot of people feel that way. Yeah, intentional infliction of emotional distress, which actually I believe is one of the pieces that Blake Lively pulled from her complaint against that other fella, Jesse. I don't remember his name. But she had multiple claims in her complaint when we went through that. And it's actually pretty hard to prove intentional infliction of emotional distress. And that's very hard to prove. And I think out of her entire complaint, those were the weakest links as far as showing the causal relationship. So I thought that was actually wise of her to pull those so they can focus on the winning pieces in her complaint. But yeah, those are hard to prove. Step down because of the charges, end up representing Garcia. No, that would be a conflict of interest. That would be a pretty significant conflict of interest. Yeah. Therapist, because he's, oh, I know. The hardest thing with that is showing that you in particular were the one they were aiming the harm to. That tends to be the piece that people get tangled up on. Yeah. Oh, the traumatizing. Oh, I know. Thank you so much. All right. So let me dive in here. Oh, I know. I know there's a lot. This is just the beginning, everybody. This is just the beginning. And our system works so slowly that right now we're like, oh, we got what, 200, almost 270 cases now, 265 cases. Like, this is just the beginning. I mean, this is going to be going on for years and years and years. Like right now, we still have a lawsuit against Mr. Orange regarding January 20th for people who were injured, for some of the DC police that were injured, and various other people that were at the Capitol that day. That lawsuit's still going. I mean, it's 5 years later, it's still going. So we're still working on getting it into court, getting discovery done and such. So all of these 265 cases, it's ongoing. So it's gonna keep going and keep going and keep going. Okay, here we go. So if Garcia was ordered removed in 2019, he wasn't ordered removed. That's the problem. Okay, can I file a class action for discriminating against you? Yes. Well, maybe, I don't know. If you've got a discrimination issue, the first place you want to go is the ACLU. And you want to see if if they've already got something pending. All right? Isn't Garcia a victim of a crime? Unknown right now. Unknown. We aren't sure. We will have to see. January 6th. Thank you, Neil. I appreciate that. I'm getting January 20th and January 6th mixed up because January 20th was the day when all of the executive orders hit the fan versus January 6th when we had all the charges in 2020. So if you see January 20th and then January 6th, 2020, they're getting tangled up. All right. Let me dive in here, everyone. Here we go. 1983 suit, possible. Again, ACLU is the best place to go for that. So we've got an ethics complaint against Pamela Jo Bondi here, filed yesterday, looks like. Regular people, you don't have to be a lawyer to file an ethics complaint. All you have to have is information where you think a rule's been violated and evidence to back it up. So here we go. The undersigned attorneys, law professors, and former judges. See, if it says former judges, those are like the young dinosaurs, all right? File this complaint seeking an investigation and appropriate sanctions against Pamela Jo Bondi, a member of the Florida Bar, who has engaged in serious professional misconduct that threatens the rule of law and the administration of justice, which, that's an ethical violation. So number one, Miss Bondi's Florida Bar number. Oh, this is good information to have. Here we go. In case anybody else wants to file an ethics complaint, just make sure, though, that it's, properly done and that it's really fleshed out. You don't want to have this turn into a Judge Cannon situation where, after 1,000 complaints, the bar's like, no more, please. Let's work on what we've got. So, don't be all willy-nilly. This isn't like you don't want to spam them. But if you've got a proper form and a proper fleshed out situation, go for it. That's always important. All right, so there's her bar number. Oh, and here's her contact information, which is available publicly. Here, we're not doxing anybody. Number two, Florida Bar Association, quote, an apparently isolated violation may indicate a pattern of misconduct that only a disciplinary investigation can uncover. And so that's what they're asking for here. This isn't like, okay, we're charging her. This is hey, committee, we think there's a problem. Can you investigate this? Because that's what your job is. All right. Then, right. Yes, it certainly can be. Here we go. So we file this complaint recognizing that Miss Bondi currently serves as the Attorney General of the United States, the highest ranking lawyer in the United States government. Indeed, we bring Miss Bondi's misconduct to your attention precisely because Miss Bondi holds this exalted position with the attendant responsibilities for subordinate lawyers under her authority who carry out her directives, and because the complaint highlights for the entire legal profession the importance of ethical rules to our independent self-regulating profession. That's important. Likewise, we filed this complaint notwithstanding the Florida Bar's recent reply to 2 previous ethics complaints filed against Ms. Bondi that it does not investigate or prosecute sitting officers appointed under the U.S. Constitution while they're in office. What's that crap? Let's pull that out. Let's take a peek at this. Does not investigate or prosecute sitting officers appointed under the U.S. Constitution while they are in office. That's interesting. So let's bump down. Number 3, letters from Allie Houston. It seems like if they're actually practicing and their job is what's unethical, like, you should be able to investigate or at least look into it. Oh, I didn't know that. Apparently they have a rule. So I guess the Florida Bar has some kind of rule saying that they won't go forward to investigate. Well, I mean, you don't have to prosecute. You don't have to prosecute. That's fine. But not to even investigate, that's questionable. Yeah, I agree. The purported rationale for declining to investigate or prosecute is that such action could encroach on the authority of the federal government concerning these officials and the exercise of their duties. So they're so busy trying to protect the authority of the federal government that they won't investigate if it's being abused. So that doesn't make sense, but, call me crazy. Here we go. The Florida Bar's dismissal is unsupported by history or precedent. Ooh, they're going after the bar here. That's nice. As the Supreme Court has held, since the founding of the Republic, the licensing and regulation of lawyers has been left exclusively to the states and the District of Columbia within their respective jurisdictions. The states prescribe the qualifications for admission to practice and the standards of professional conduct. They also are responsible for the discipline of lawyers. Number 5, and that's the case they're quoting here is Lice v. Flint down here, 1979. That's really interesting. Man, I tell you what, I get it. That qualified immunity stuff is like really important, but on the other hand, it's like, so we just don't investigate people until they're out of office years after the harm's been done. Like, what? Here we go. Accordingly, this policy of the Florida Bar is an abdication of its jurisdiction and its responsibility to regulate the legal profession. Indeed, this policy means that the bar will exercise no authority over the behavior of lawyers licensed in Florida who happen to be appointed as an officer of the United States. In other words, any such lawyers, including the Attorney General, are professionally unaccountable. Yeah, that's an issue. I would say that's an issue. Number 6, we note that although the Florida Bar may not, pursuant to Rule 3-7.16d of the Florida Rules of Discipline, investigate bar complaints against constitutional officers until after they vacate office, this limitation only applies to officers appointed under the Florida Constitution. Ooh, we like that. So it says the Florida Constitution. So if you're appointed under the U.S. Constitution is what they're saying. So that's interesting. We like that. In any event, school board members are now accorded constitutional status by Article 9, Section 4A, Florida Constitution. And then also 112-3142, Florida Statute 2025, defining constitutional officers for the purpose of ethics training to include the governor, lieutenant governor, the attorney general, the chief financial officer, the commissioner of agriculture, state attorneys, public defenders, sheriffs, tax collectors, property appraisers, supervisors of election, clerks of the circuit court, county commissioners, district school board members, and superintendents of schools. Ooh, she's not included. So what they're saying is the USAG isn't falling into that category. That's interesting. Yeah, I like it. We love the loopholes. We love the creativity here, everybody. All right, so that is footnote number 6. In other words, right, held unaccountable. The rule not only require that lawyers who are public officials are accountable for their ethical conduct, but specifically declare that lawyers who are public officials have a higher duty than other lawyers to maintain ethical standards. Quote, lawyers holding public office assume legal responsibility going beyond those of other citizens. A lawyer's abuse of public office can suggest an inability to fulfill the professional role of attorney. Nowhere in the rules or comments is there an exception for lawyers who are federal public officials. Moreover, the McDade Amendment, 28 U.S. Code Section 530B, plainly makes Department of Justice lawyers subject to state bar rules. Therefore, we ask the Florida Bar to do its duty and investigate the serious professional misconduct discussed herein. So let's look at footnote 8 here. All right, and then we've got infra discussion on pages 10 through 11. So before I jump too far, everyone, I know a lot of people come and hang out on these lives, not just for the documents, but also for the analysis. So I appreciate all of you, and I know some people are just like, just read the document, but it's a mixed bag here. Let me explain something here. When we're talking about a duty is one of the 4 elements of negligence, or if you're to bring a lawsuit. So if you want to sue somebody or bring a lawsuit, you have to prove that they had a duty, all right? So they had a duty, there was a breach of that duty, there's a causal link, so then there's causation, and then there's some kind of damage or remedy that can be done by the court, all right? Those are the 4 pieces that you need. So when they're saying that there's a heightened duty, they're saying this duty piece isn't just that of a lawyer, it's of someone who's in office. So they actually have a higher level. So a lot of times if you have someone in a position where they have a duty to people, but they also have a special duty to children, then that means your duty's higher than most people. So something like this could be seen as, what they're arguing is they're trying to say, yeah, you do have, a responsibility, but to follow the ethics rules. But if you are in public office, if you are in a public office, you actually have a higher duty than all of the other attorneys. And so you shouldn't be not investigated. You can't hold the investigation back because they're actually more important to make sure that they're staying on task here. The full show, the cat hair, the law, the cat hair. Oh my goodness, yes. All right, here we go. So just again, to give you some idea of what they're arguing about, they're saying if you're in office, like the highest ranked attorney in the United States, you've got a higher duty and you need to be watched more carefully here. Summary of the complaint. The gravamen of this complaint is that Ms. Bondi personally and through her senior management has sought to compel Department of Justice lawyers to violate their ethical obligations under the guise of zealous advocacy. This term zealous advocacy is a very controversial and can be used quite a bit as a defense for a lot of people. Well, I was just zealously advocating for them. Like, you still have to be ethical. As announced in her memorandum to all department employees issued on her first day in office, threatening employees with discipline and possible termination for falling short. And we have footnote 9. I think our footnotes are going to be key here. So number 9, memorandum, U.S. Attorney here. Oh, it looks like you can pull the memorandum up for anyone interested. Here is the website. You can pull that memo up. She has exerted this pressure even though the rules of professional conduct limit the zeal of attorneys to lawful and ethical measures. And then we're citing the Florida Bar Rule here, 4-1.3. Here, right? So you got to limit your zeal. Such conduct violates Florida Rule of Conduct 4-8.4a, which makes it misconduct for a lawyer to knowingly assist or induce another to violate the rules of professional conduct. Rule 4-5.1, which imposes ethical duties on Ms. Bondi to take reasonable measures with respect to her managerial duties as Attorney General and her supervisory duties over subordinate lawyers to ensure that lawyers in the department comply with their ethical duties And Rule 4-8.4D, which prohibits a lawyer from engaging in conduct that is prejudicial to the administration of justice. So this is kind of a big one. We've talked about this particular rule multiple times here, because if you are intentionally causing prejudice to the judicial system, it's a problem. Way too subjective. Yes, I agree. The DC, yeah, I don't know what's happened in the DC bar. I'm not licensed in the DC bar, so I don't know what's going on over there, but all right, there we are. And then next, in this complaint, we highlight 3 glaring examples of department lawyers being terminated or forced to resign as a result of demands that they act unethically issued by Ms. Bondi or a member of her senior management, including Emile Bove. Oh, this fella right here. Oh, I don't know about that one. Initially, the acting deputy attorney general, the number 2 position in the department, and now the principal associate deputy attorney general, the number 3 position, Todd Blanche, the current deputy attorney general. Oh, I don't know about that fella. And Edward Martin, the interim U.S. attorney for the District of Columbia, now chief of the Justice Department's, quote, weaponization working group and department's pardon attorney. Ooh, the pardon attorney. The pardon attorney is that's not good right here. Wow. Conflict of interest. Yes. Wow. So all of the pardons right now that people are buying are going through him. Wow. Okay. Here we go. Yes. The one that took Liz's spot. Yeah. I feel like we should be running a campaign, give Liz back her job, but I don't know that I'd want to work in this kind of a environment. The simplest, most alarming example, Miss Bondi and her deputy, Mr. Blanche, fired an experienced and accomplished attorney, Erez Ruveni. Oh my gosh, I'm so sorry, Mr. Ruveni. Yikes, for telling the truth before a tribunal in the case involving Kilmar Garcia. This is the person responsible for Mr. Garcia not being lost. All right, so that's important. He represented contentious immigrant cases for the government. His candor lost him his job. Oh my gosh, that's heartbreaking. Who was deported to El Salvador due to an administrative error and contrary to a court order that he not be deported to that country. So I think that's okay. We've got some heroes here. Yeah, so let's highlight the heroes here. Mr. Ruveni. And I think we all kind of knew that as soon as we heard that phrase, administrative mistake. We knew that someone actually with integrity made that announcement, because no other mistakes are ever acknowledged here. Okay, the second example is the forced resignation of Denise Chung, who, is it Chang? Oh my gosh, I'm so sorry. Who had served as in the department for nearly a quarter century. She declined to open a criminal investigation because there was insufficient predication. All right, so she's like, no, we don't have enough to open the case. And the third example of this pattern of conduct occurred when the department proposed to dismiss the criminal indictment against Mayor Eric Adams of New York without prejudice in exchange for Mr. Adams's assistance on immigration enforcement. Because the dismissal was based on an improper quid pro quo, the acting U.S. attorney for the Southern District of New York and almost a dozen other lawyers in that office and the department's public integrity section objected to the proposed dismissal. As a result, they were forced to resign immediately or placed on administrative leave, and later resigned rather than express regret for the prosecution. All right, so then the other, number 3, are the New York attorneys. So if you've got integrity, you're gone. Oh my gosh, yeah. Oh, all right. Sorry, everybody. It takes a minute here when you think about it. Again, this isn't small potatoes. These are career attorneys that have spent their entire lives, right, working in this field. And this isn't an easy job. This is not an easy job. To be a prosecutor for this long, you see the absolute worst of this country, the absolute worst, but you still get up and go to work the next day. And here they're like, well, we don't like these people, go after them. And they're like, well, we're not going to do that because that's against the Constitution. And then they're like, well, you're done. Like that's pretty awful. All right, through her zealous advocacy memorandum and its application in these 3 cases, Ms. Bondi has sent a message to all Justice Department lawyers that they must disregard the applicable rules of professional conduct, fundamental ethical principles, and long-standing norms of the department in order to zealously pursue the president's political objectives. And if they fail to do so, they will be disciplined or fired. However, as Ms. Bondi and her senior staff are fond of saying, no one's above the law, because they like to say things they don't believe. Number 12 down here is a citation to a link regarding Judge Hannah Dugan. Yikes. And this includes Miss Bondi. All right. This complaint will first describe Ms. Bondi's and her senior manager's conduct in connection with these examples. It then identifies the ethical provisions she likely has violated and explain how her actions endanger the rule of law and the administration of justice. So this next part I think is really important if you are wondering. Now, I have a pack here. I'm not sure I'm going to be able to grab it at the moment, but we were going through and talking about who the, well, let me see if I can find it just real quick. Here. I'll put Bernie up here for a second. So I've got a list here of the attorneys in the Department of Justice. And any of these attorneys you can file, thanks Bernie, you can file ethics complaints against, right? So we've got, well, that's the Sentencing Commission. Wait, where'd it go? Oh, wait, wrong folder, sorry. You can file ethics complaints against them. Oh, here we go, the DOJ list. Oh, we like the Bernie. I like Bernie because he brings some kind of serenity. I had to get that after he was the one that told the 2 fellas, I can't remember what hearing it was, but they're like, yeah, you want to fight about it? You want to fight about it? You want to take this outside? And Bernie was like, you are a senator. Come on. Or you're a congressman. Don't act that way. After that, I was like, all right, you had me at hello. All right, I digress, everyone. This is what I'm talking about here. We've got these people here in charge in the DOJ, and the analysis they're about ready to use here for Miss Bondi, you can use for each and every single one of these people for any of the cases that they're on, all right? So if you are watching these cases and saying, wow, these filings are awful, then, you're going to be able to use the same kind of an analysis. So let me just show you the top people here. Let's see, how's the filter? Yeah, there's the filter, everybody. All right, so this is Yakov Roth here. He has been the one who's been speaking about a lot of the, yes, a lot of his filings absolutely would be seen as possible violations. Then we have Deputy here, Assistant Attorney General, Federal Programs Branch, this Eric MacArthur person. And then we have Eric Hamilton here, Deputy Assistant Attorney General, Office of Immigration Litigation. So he was the other one that was named here. And then this fella, this Drew Ensign fella, that's some bad business right here. I think he's out of Florida also. But this one's got some bad business going on here. It's right here. This is the other one where I have folders of the filings where there have been ethical breaches. And so he's got the most. Deputy Assistant Attorney General, Torts Branch. And then Jonathan Guyon, this fella here. And I think that's the last one. So those are kind of like the major players out of the civil division, out of the AG's office. So just so you know. So I wanted to pause for a minute and just say, if you are wondering what it's going to look like to file an ethics complaint against any of those people, this is going to be the format that you're going to want to use, all right? So factual statement, A, Ms. Bondi's zealous advocacy memorandum. On her first day as Attorney General, February 5th of 2025, it seems like it's been 50 years, but it's not. Ms. Bondi issued a memorandum to all Justice Department employees entitled General Policy Regarding Zealous Advocacy on Behalf of the United States. It states in part here, it's the job of an attorney privileged to serve in the Department of Justice to zealously defend the interests of the United States. Those interests and the overall policy of the United States are set by the nation's chief executive. Oh my goodness. Oh goodness gracious. Who is vested by the Constitution with executive power. More broadly, attorneys are expected to zealously advance, protect, and defend their clients' interests. Department of Justice attorneys have signed up for a job that requires zealously advocating for the United States. Yeah, right. Oh my goodness gracious. Goodness gracious. Okay, number 2, the responsibilities of Department of Justice attorneys include not only aggressively enforcing criminal and civil laws enacted by Congress. Where's the Constitution? What about the Constitution? I'm just going to put that out here. I feel like it's not being mentioned. But also vigorously defending presidential policies and actions against legal challenges on behalf of the United States, which they're doing. There's like 268 cases going right now. 265 cases. Okay? So every single lawsuit brought against this administration is being defended by the Department of Justice. All right, let's just make sure we all understand what that means, okay? The discretion afforded the department attorneys entrusted with these responsibilities does not include latitude to substitute personal political views or judgments for those that prevailed in the election. The judicial, no, it's part, no, Christina, it's part of the executive branch. Yeah, I mean, that's why we've got, real quick, here. So that's why we have, where's she at? Here we go. We've got, this is the president's cabinet here. All right. So we've got labor, state, transportation, treasury, veterans affairs here. Court calendar here. Oh, nope. That's the immunities decision here. Okay. Here we go. Department of Agriculture, Commerce, Defense, Education, Homeland Security. Of course, it's always on the last page. Energy, Department of, of course, it's the last one, everyone, of course. Department of Justice right here is the cabinet position with Bondi. All right, so they are specifically answering to the president. Now, when we had a different president, someone was in there saying, whoa, they're using the DOJ to weaponize whatever. And we're all like, no. But now, yeah. Yep, that's happening. Right. I know. All right, so here we go. Number 1, number 2, number 3. When the Department of Justice attorneys, for example, refuse to advance good faith arguments by declining to appear in court or sign briefs, it undermines the constitutional order and deprives the president of the benefit of his lawyers. Oh my gosh, everybody, we got to break this apart. This is, oh my gosh. Okay. So it looks like what they had were attorneys that were like, I'm not going to go to court. I'm not going to sign that brief, which I think is what happens in the Eric Adams situation, because Bove had to come in and sign that pile here. And so they're saying, if you don't show up, it's undermining the constitutional order, deprives the president of the benefit of his lawyers. The DOJ are not his lawyers. Right? They are the lawyers for the United States. They are United States lawyers, but they go through the executive branch because they are enforcers, and that's what the executive branch does. All right. Now, the judicial branch is supposed to be, in the middle. So just neutral. And the congressional legislative branch, obviously, right, is the elected branch. And then the executive branch are the ones that say you violated the law and let's go forward on it. And then we'll go through the judiciary. So that's why we've got the Justice Department in the executive branch. They are not his attorneys they're not supposed to be his attorneys, but I can see now this policy where they're saying he is their client rather than the United States. Yeah. Disqualifier. Yes. If she loses her law license, she wouldn't be able to practice. All right. It is, therefore, the policy of the Department of Justice that any attorney who, because of their personal political views or judgments, declines to sign a brief or appear in court, refuses to advance good faith arguments Yeah, that's the other thing too, is that the arguments that have been made many times are not good faith, and that's what actually makes them an ethical violation. On behalf of the administration or otherwise delays or impedes the department's mission will be subject to discipline and potentially termination consistent with applicable law. And that's why there's only like 10 attorneys left in the DOJ. All right. All right. So here we go. This is all very stomach turning here for sure, but whatever. No, Nick, the president of the United States is an executive officer of the United States. He does not represent the United States. The people elect representatives in Congress, right? So he enforces the law that Congress makes. The president can't make any laws. So he's basically, you know, a eunuch. It's up to Congress. That's really where the power is. As subsequent events demonstrate, the zealousness intended by Miss Bondi's memorandum entails the routine violation of ethical strictures applicable to department lawyers and has resulted in these lawyers being fired or complying with those limits or forced to resign rather than violate their ethical obligations. Yeah, that's an ongoing issue. Okay, B, Kilmar Garcia litigation. So one more thing too to keep in mind, when we go through, if anything happens and Garcia sues the government, I don't know if he's going to be able to do that or not, or any other kind of action goes on, this level of information may not be the same. You get more information to put into an ethics filing than you would get in any other kind of case because of the rules of evidence. Here you can put whatever you want in here versus, the very strict rules of evidence for a criminal or civil case. All right, so we're going to hopefully see some stuff in here that we've not seen before. I said what I said. I certainly did. I did. Kilmar Armando Abrego Garcia is an El Salvadoran citizen. He entered the United States around 2011. In 2019, Immigration and Customs Enforcement instituted removal proceedings against him. In response, Garcia sought a withholding of removal order, preventing the United States from removing him to El Salvador. That order was issued in October of 2019. After the immigration judge agreed, it was more likely than not that Garcia would be persecuted by GANGSs if he were forced to return to his home country. The government did not appeal that order, so it became effective. Oh no, I've got a puzzle piece, everybody. Oh my gosh. Oh my gosh, the puzzle piece. Hold on a minute. Oh my gosh, wish me luck. I get so nervous. Here we go. Are we going to get it? Oh, we got it in the first try. Yay. Oh my gosh, that's so stressful. For those that don't know, TikTok has this puzzle piece you have to put into a puzzle in order to make sure that you're still live, I guess, because there were a lot of lives where people were just sleeping and doing various other things. So now it's like you have to put the puzzle piece in, but if you have vision issues, it can be very stressful. All right, here we go. Back into it. Right. And again, this whole situation too, we cannot forget about CAT, which is that treaty involving the United Nations, so international law as well. In March of this year, Mr. Garcia was detained by ICE without notice or legal process, flown to El Salvador and placed in the notorious CCOT. March 24th, his family filed suit in federal district court in Maryland against several federal defendants, including the Secretary of Homeland Security and Miss Bondi. They also sought an emergency temporary restraining order, asking the court to order the defendants to request the government of El Salvador to return Mr. Garcia. The government filed its response on March 31st, arguing principally that the district court lacked jurisdiction for several reasons, and that it was not likely that El Salvador would respond positively to a request from the United States. Critically, the response conceded that on March 15th, although ICE was aware of his protection from removal to El Salvador, Abrego Garcia was removed to El Salvador because of an administrative error. So let's hop down and take a look here. At our footnotes. So all of the factual statements in this and the following paragraph are drawn from the complaint that's been filed in court. Number 18, the department's opposition was signed by Yakov Roth. Oh, here we go. This fella. All right, this is the fella right here. All right, acting assistant attorney general here. And these fellas. Right, and then as defendant in this case, represented by the government's lawyers, as well as those lawyers' supervisors, Miss Bondi should be bound by this assertion. So again, moreover, lawyers are agents of their clients. Clients are therefore bound by what their lawyers assert in a case. Alrighty. At the April 4th hearing on the TRO motion, it depends on if the administrative error is in good faith or bad faith. I think that really does play a role here. The government was represented by Erez Ruveni, the acting deputy director of the DOJ's Office of Immigration Litigation, and one of the DOJ lawyers who signed the March 31st response. As such, Mr. Ruveni had no option but to say at the outset, consistent with the department's March 31st response, quote, "We concede the facts. This is why Garcia was not lost." All right here, because of what this man said. This person the plaintiff, Abrego Garcia, should not have been removed. In an exchange with the court, he explained why. There was a withholding of a removal order, now final, that forbade the government from returning Mr. Garcia to El Salvador. As a result, he acknowledged, quote, "There's no dispute that the order could not be used to send Mr. Abrego Garcia to El Salvador." When the court pressed him on what document the government had relied upon to initiate Mr. Garcia's removal in 2025, Mr. Ruveni again had no option but to concede, quote, "That's not in the record, and the government has not put that into the record, and that's the best I can do." This is where an attorney is in court being asked questions and has no backup. There's no backup from his client or the office. He's got no information because they didn't give him any information. Similarly, Mr. Ruveni had to concede that the withholding of the removal order meant that, as a matter of law, Mr. Garcia could not be removed to El Salvador, and that there was no case directly on point to Your Honor's question. The court thanked Mr. Ruveni no less than 3 separate times for his candor. Mr. Ruveni did point out that there was a dispute between the parties, and he argued at some length why the government believed the court had no jurisdiction in the case. So he tried. Right? He tried. And yet, the very next day, Deputy Attorney General Todd Blanche placed Mr. Ruveni on administrative leave for failing to follow a directive from your supervisors, engaging in conduct prejudicial to your client, and not zealously advocating on behalf of the United States. And the next day, Miss Bondi appeared on Fox News Sunday and made it clear that Mr. Ruveni's suspicion was a direct consequence of her February 5th zealous advocacy memorandum. You know, this Blanche fella, I may need to bring some of those transcripts out from the New York trial where he's just over and over and over again getting shot down by the judge because he doesn't know what he's doing. I may need to do that. All right, here we go. I know he's had a lot of experience, but there are some situations where his arguments are just so outside of the realm of reality that the judge was like, what are you even talking about? He was put on administrative leave by Todd Blanche on Saturday, and I firmly said on day one, I issued a memo that you are to vigorously advocate on behalf of the United States. Our client in this matter was Homeland Security. He did not argue. He shouldn't have taken the case. He shouldn't have argued it. If that's what he was going to do, he's on administrative leave now. You have to vigorously argue on behalf of your client. So they were cooking the BS up. Absolutely. So this whole situation, again, everyone, and I cannot emphasize this enough, that had Mr. Yakov Roth been the one actually in court, they never would have said an administrative error or we made a mistake or conceded at a point that would have allowed for enough of a grounds for the courts to go forward and say, get him back. So if it had been this fella, in my opinion, truly would never have seen him again. It would have just, gone down the way that they wanted it to go down. But this attorney did his job, followed his ethics. Here we go. The Fox host Shannon Bream twice pointed out that the government had admitted there was an error in deporting him. Neither time did Miss Bondi dispute that assertion, nor did she explain how Mr. Ruveni could have done so. Rather, she simply said that Mr. Ruveni's conduct would be a defense attorney walking in, conceding something in a criminal matter that would never happen in this country. Oh my gosh. Sometimes I'm going to keep some of my comments to myself here. All right. 10 days later, Mr. Ruveni was fired by Mr. Bove at Miss Bondi's direction. Also another one that got smacked down a lot in the New York trial too. I'm trying to remember because they were not the attorneys that did the cross-examination of Stormy Daniels, but they did do cross-examination of multiple other people. So, and then I think it was Blanche that did Michael Cohen's cross-examination, and that was just a mess, right? Mr. Blanche also suspended Mr. Ruveni's immediate supervisor, August Flinty, for failure to supervise Failure to supervise? They fired him for failure to supervise. Yikes. All right. Number 33. The facts in this section are drawn from Read the Resignation Letter by Denise Chung, a veteran D.C. federal prosecutor, in the Washington Post. Yikes. All right. So there's our receipt here. All right. Does he have a claim for unlawful termination? That's a tough one. I think that's a tough one. It's, in this situation, when we have a federal labor relations board member who has been terminated years before the contract is up, and the Supreme Court's like, whatever, it's going to be incredibly hard to come in and say, wrongful termination, right? When we had the labor relations board member actually under statute could only be removed for cause, and they're like, whatever, we don't care. So I think this is just a dangerous area that they're in, that they're abusing, in my opinion. C, EPA clean energy contract investigation. All right, here we go. I'm gonna say Denise Chung, and I apologize if that's incorrect. She had served for 24 years in the Department of Justice and the U.S. Attorney's Office in the District of Columbia. She was most recently the chief of the criminal division of that office. Wow, that's like a lot of work. On February 17th, the department's office of the Deputy Attorney General, ODAG, then headed by Mr. Bove in an acting capacity, instructed Ms. Chang to open a criminal investigation into whether the EPA had unlawfully awarded a clean energy project contract and to issue grand jury subpoenas pursuant to the investigation. Okay. She was instructed to take that action by close of business that evening to prevent the contract awardees from drawing down contract funds held by Citibank. Does anybody remember this when this happened? I mean, this was, oh my gosh. Ms. Chung conferred with colleagues with substantial white-collar criminal prosecution experience, reviewed documentation provided by ODAG, and concluded that the documents on their face did not prove the predicate for opening a criminal investigation, which is part of your job as a prosecutor. You have to look at the evidence that's in front of you and decide whether or not you've even got enough to go forward so that you're not indicting a ham sandwich. After much internal debate, ODAG said a freeze letter requesting that the bank freeze the funds would be adequate. Ms. Chung contacted the FBI's Washington field office to start that process. She also viewed a Project Veritas video that ODAG claimed provided probable cause. Ms. Chung sent a draft freeze letter to the principal deputy U.S. attorney for the District of Columbia, PA-USA. Oh my gosh. The PA-USA proposed inclusion of language stating that the government had probable cause to believe that contract funds held by the bank were subject to seizure and forfeiture. She said the language was not appropriate based on the evidence she had reviewed. She provided the FBI with an alternative language that said there may be conduct that constitutes potential violations of the federal criminal code that merits additional investigation. The FBI issued the letter to Citibank at 7:28 p.m. The PASA and interim U.S. Attorney Martin called Ms. Chang shortly after. I'm struggling with the E and the U together, everybody. I gotta pause. I know when I say the name wrong every time, it's gonna be triggering people. And I have a hard time with this because this to me makes it sound ugh. And so I'm having a hard time. Can anyone help me here? Chat, help me out. I don't want to be disrespectful here to Miss Chung. Thank you. Sure. Tea break. Chung. Okay, it is Chung. All right. I'm putting too many words in. Okay, I'm putting too many extra letters in. Okay, I got it. Chung. Okay. Oh, thank you so much. Thank you, everybody. I appreciate it. See, what happened is I've been working on my Korean today. I took a break from my Mandarin and I'm all mixed up. All right, here we go. Ms. Chung, shortly afterwards, objecting to the language of the freeze letter and directing Ms. Chung to immediately send a second letter to the bank, signed by herself and Mr. Martin, announcing the commencement of a criminal investigation, ordering the bank not to disburse any funds. Ms. Chung responded that she continued to believe there was insufficient evidence to issue such a letter. Even for a letter, if there's not enough evidence for a letter, that's a lot. Shung? Someone say Shung? Thank you, Dubs. Okay. Including insufficient evidence to tell the bank there was probable cause to seize the accounts that had been identified. There's not even probable cause? Wow. Because Ms. Shung believed she did not have legal authority to send the letter, she told Mr. Martin she would not send it. Mr. Martin then asked her for her resignation. Oh my gosh. She's like, there's not probable cause. It's like, all right, well, you need to resign then. Oh my gosh, that's awful. Which she submitted the following day. Mr. Martin then personally submitted an application for a seizure warrant not signed by any other prosecutors in his office. A U.S. magistrate judge rejected it on the grounds that the application, which included an affidavit from an FBI agent, failed to establish a reasonable belief that a crime had occurred. Mr. Bove then approached at least one other U.S. attorney's office in the southeastern U.S. about launching a grand jury investigation of the same contract and seeking a court-ordered bank freeze, but prosecutors in that office also refused to do so. This is so bad. What this is smacking of at the moment is the prohibition days, right? When the courts and law enforcement and people in power were absolutely bootlegging and dealing in the sauce. So everyone was corrupt. This is what this is smacking of right now, is that era in our history. Right, mob boss, exactly. All right, dismissal of Eric Adams' prosecution. In September of 2024, the department indicted Eric Adams, the mayor of New York City, on 5 counts arising from his alleged solicitation of illegal campaign contributions from foreign nationals. Shortly after the election, Mr. Adams and his defense team initiated contact with Trump's staff and ultimately met with the president-elect himself. On January 31st, Mayor Adams' counsel met with the then acting Deputy Attorney Bove and the prosecutors working on the case led by Danielle Sassoon, the acting U.S. Attorney for the Southern District of New York. At that meeting, as documented by Ms. Sassoon, the mayor's counsel indicated that he could be helpful to the administration's immigration enforcement priorities if he was no longer facing prosecution. Oh my gosh. I think that deserves a highlight. Oh my goodness gracious. Also, as reported by Ms. Sassoon, in her resignation letter, Mr. Bove admonished a member of my team who took notes during that meeting and directed the collection of those notes at the meeting's conclusion. He wasn't living in New York City. Really? That's interesting. February 10th, Mr. Bove sent a memorandum to Ms. Sassoon stating that he was acting pursuant to the authorization of the Attorney General. The memorandum instructed her to dismiss the indictment after obtaining Mr. Adams' consent to dismissal of the indictment without prejudice to it being refiled. Mr. Bove's memorandum provided 2 grounds for dismissal. 1, doing so would enable Mr. Adams to assist in immigration enforcement. And 2, Damian Williams, Ms. Sassoon's predecessor, improperly weaponized the prosecution. Mr. Bove's memorandum also stated that the decision to dismiss had been reached without consideration of the merits of the prosecution. So, yeah, that's weird. I remember going through these letters when this hit the fan. And the letters, there was a lot. There was a lot going on in those letters. Miss Sassoon wrote Miss Bondi on February 12th to request a meeting and express her grave misgivings about this memorandum. She expressed concern that the agreement with Mayor Adams to consent to dismissal had been negotiated without my office's awareness or participation. She explained that offering to drop the prosecution in exchange for a promise of assistance violated the Department of Justice manual and the rules of professional conduct and would constitute prosecutorial misconduct. She also explained that Mr. Williams had very little involvement in the investigation, that the decision to indict originally with career staff, and Mr. Williams' public statements were typical for a U.S. attorney. Moreover, she added, dismissing without prejudice and with the express option of again indicting Adams in the future creates obvious ethical problems by implicitly threatening future prosecution if Adams' cooperation with enforcing the immigration laws proves unsatisfactory to the department. Right. I'm just wondering now, I'm thinking now about how the courts got pulled out of that prohibition era where, the judges were like in the, underground rooms gambling and drinking. I'm wondering how we did pull out of that. I don't think I've ever really paid attention. Miss Sassoon, other than that the constitutional amendment was changed, right? So after that, it was all above board. Perhaps that's what it was. Ms. Sassoon said, I am mindful of your recent order reiterating prosecutors' duty to make good faith arguments in support of the executive branch's positions. Citing that memo, general policy regarding zealous advocacy on behalf of the United States. But because I do not see any good faith basis for the proposed position, I cannot make such arguments consistent with my duty of candor, which is what's required under our ethics, candor to the court. Yeah. Exactly. She offered to resign if Miss Bondi chose to not meet with her or to reevaluate the dismissal directive. Mr. Bove responded on February 13, accepting Miss Sassoon's resignation and placing the 2 lead prosecutors on administrative leave, pending an investigation of all 3 attorneys in subordination by the Office of Attorney General and the Department's Office of Professional Responsibility. The letter quoted from the Zealous Advocacy Memorandum and added, your office was not exempted from the Attorney General's memorandum. Wow, that's awful. That same day, Mr. Bove transferred the Adams prosecution from the Office of the U.S. Attorney for the Southern District of New York to the Department's Public Integrity Section. The 2 leaders of the Public Integrity Section and 3 other lawyers were promptly resigned. They are promptly resigned rather than participate in dismissing the case. I think that was the moment, too, when we were all saying, how far down the line are we going to go? How many lawyers are going to resign until they find somebody without any ethics to actually go forward and sign it, right? Rather quick. Well, exactly. You got to follow your ethics. Again, that oath is to the Constitution. It's not to a person. It's not to a policy. It's to the Constitution itself. So Ms. Sassoon resigned on February 14th, along with one of the 2 lead prosecutors. Also that day, Mr. Bove held a conference call with the remaining lawyers in the Public Integrity Section, stating that 2 of them would need to sign the dismissal motion, or it was strongly implied that they would all be fired. He gave them 1 hour to decide. What is this? Is this like, are we driving around with something attached to a bus? It's like you have 1 hour to decide what's going to happen or this bus is going to go. A senior section lawyer offered to sign the motion to protect the other lawyers, and it was ultimately filed that day with additional signatures of Mr. Bove himself. See, there's the one without ethics that could sign it. And the then head of Department of Criminal Division. On April 22nd, 3 of the prosecutors who had been placed on administrative leave resigned. They explained that Mr. Blanche, newly appointed as the Deputy Attorney General, had, oh my gosh, conditioned their return to service on expressing regret and admitting misconduct in connection with refusing to dismiss the Adams case. They resigned rather than abdicate our legal and ethical obligations in favor of directions from Washington. Wow. That's a lot. All right, let's take a look at the ethical rules now. We got one more paragraph here. I was like getting so excited about the rules, but we've got one more paragraph. Here we go. On April 2nd, Judge Dale Ho reluctantly dismissed the indictment, although he did so with prejudice, declaring that everything here smacks of a bargain dismissal of the indictment in exchange for immigration policy concessions. Judge Ho also rejected the department's claims of misconduct by the Southern District prosecutors. There is no evidence, zero, that they had any improper motives. All right, here's our rules. So applicable rules. Number 1, Miss Bondi. The McDade Amendment makes plain that an attorney for a federal government's bound by the state laws, ethical rules, and federal court rules of the state, which such attorney engages in that attorney's duties to the same extent and in the same manner as other attorneys in that state. With prejudice means that the court is saying, you're not allowed to bring it back. So, if it's without prejudice, of course you can bring it back. But yeah, well, I think so. I think we've had eras when we've had attorneys leave the DOJ. Not at this level. I've not seen the sheer quantity of it at this point. Here we go. Miss Bondi is a member of the Florida Bar. Under Rule 4-8.5, the Florida Rules of Professional Conduct, she's subject to the disciplinary authority of this jurisdiction, although engaged in practice elsewhere. The comment to this rule adds, tea break. In modern practice, lawyers frequently act outside the territorial limits of the jurisdiction in which they are licensed to practice, either in another state or outside the United States. Sorry, everybody, just one moment. In doing so, they remain subject to the governing authority of the jurisdiction in which they are licensed to practice. If their activity in another jurisdiction is substantial and continuous, it may constitute the practice of law in that jurisdiction. See Rule 4-5.5. If the rules of professional conduct in the second jurisdictions, in the two jurisdictions differ, principles of conflict of laws may apply. Similar problems can arise when a lawyer is licensed to practice in more than one jurisdiction. Although Miss Bondi heads a federal agency headquartered in the District of Columbia, she's not a member of the D.C. Bar. Ooh, that's interesting. And therefore is not subject to the disciplinary authority of the D.C. Bar under the current rules issued by the D.C. Court of Appeals. Under the choice of law rules issued by the Department of Justice to implement the McDade Amendment, however, Miss Bondi is subject to Florida's ethical rules. The Florida Bar, therefore, has disciplinary authority over the bar complaint, and its rules of professional conduct apply to Miss Bondi's conduct that is the subject of this complaint. That's interesting. Department lawyers. Under the department's choice of law rules, the department lawyers that Miss Bondi and her senior management team supervise, one, when involved with a particular case, are subject to the rules of ethical conduct of the court before which a case is pending. And as noted above, two, where no case is pending and subject to the ethical rules of the attorney's state of licensure, unless choice of law principles direct the attorney to comply with the ethical rules of another jurisdiction. Accordingly, Mr. Ruveni is subject to the Maryland rules of professional conduct since the Garcia case is pending in federal district court in Maryland. Ms. Chung, as a member of the D.C. Bar, is subject to the D.C. rules of professional conduct. Ms. Sassoon is subject to the New York rules of professional conduct since Adams' case was pending in New York, and she's a member of the New York State Bar. Could that be used against her? Could be, sure. So does she not have to be licensed in D.C. to work in D.C.? I think that's what's so weird here. If she was actually in court working on a case in D.C., she would need to be licensed, But I'm not sure exactly how this is breaking down, because I thought she would have had to have been a member of the DC bar. I mean, you can practice federally with any license from any state, but for the U.S. Attorney General, I don't know. It seems like wherever her office is where she should be licensed, right? Yes, Robin, yes. Should the rules of conduct be the same in all states? Yes, and they pretty much are. They pretty much are. We take the examples from the model rules out of the ABA, and we pretty much make our rules exactly the same. The numbering might be a little different, but the language is the same. All right, supervisory misconduct, rules 4-8.4A and 4-5.1. Miss Bondi's principal ethical violation arises from her perversion of the concept of zealous advocacy into an overriding campaign, individually and through Messrs. Blanche, Bovey, and Martin, to coerce and intimidate the lawyers they supervise into violating their ethical obligations. In each of the examples discussed above, Miss Bondi and her senior team ordered department lawyers to do things those lawyers were ethically forbidden from doing under threat of suspension or termination, or fired them for not having done so. They're not supposed to be, Nurse Susan, they're not supposed to be partisan, and what happens is they can be a mixed bag, but also, I mean, it depends too on where you're at. It's going to vary from a place to place. So some are going to be, right down that neutral road, got to work together. Some are going to be like, we're in power here, and then it's a constant fight. So I think it truly depends on where you're at. They are partisan. She's not in the directive members under. Okay. Yep, there you go. To recap, Arez Raveni, Mr. Blanche first suspended and then fired Arez Raveni for telling the truth in federal district court located in Maryland about why Kilmer Garcia was deported to El Salvador. Miss Bondi endorsed this action in a television broadcast. But Mr. Raveni was required to make these concessions by the duty of candor to the tribunal imposed on him by Maryland Rule 19-303.3 sub A sub 1 and 4, which provide in relevant part an attorney shall not knowingly make a false statement of fact or law to a tribunal or offer evidence that the lawyer knows to be false. As noted above, the court thanked Mr. Raveni no less than 3 separate times for his candor. In subsequent appellate proceedings, 2 judges on a panel of the Fourth Circuit Court of Appeals took special note of the treatment of Mr. Raveni. Oh dear. Of note, in response to the candid responses by the government attorney to the district court's inquiry, that attorney's been put on administrative leave, ostensibly for lack of zealous advocacy. But the duty of zealous representation is tempered by the duty of candor to the court, among other ethical obligations, and the duty to uphold the rule of law, particularly on the part of the government attorney. United States Department of Justice homepage here. Our employees adhere to the highest standards of ethical behavior, mindful that as public servants, we must work to earn the trust of and inspire confidence in the public we serve. Yikes. Denise Chung, Mr. Bovey, and Mr. Martin sought to get Ms. Chung, an assistant U.S. attorney in the District of Columbia, to open a criminal investigation into a circumstance where she and her senior colleagues agreed that all the available evidence was insufficient to support such an action. She also refused to sign a letter to a bank declaring that probable cause existed to justify seizing assets held by the bank. Ms. Chung's conclusions were subsequently validated by the U.S. magistrate judge and at least one other U.S. attorney's office. So I want to take a minute and just remind everybody, does anybody remember, I think it's the Jeffrey Clark fella was in the DOJ in the environmental section or whatever, and he wanted to have the states pause the results for the election, right? This is what the nightmare was that had turned in to this giant RICO charge. Does anyone remember this letter that Clark had wanted the DOJ to put out stating that they had found a fraud. Does anyone remember that? He said, well, just write it down that the DOJ has found some fraud, and then we'll go forward from there. And they're like, we're not going to do that. We're not going to just put that language into a letter and send it, right? So we're in kind of a similar situation here. She's saying there's no probable cause to justify seizing assets. And they're saying, we'll put it in the letter anyway, right? So this, again, is just like classic technique here for this particular crew, that they can just be like, hey, who cares if it's true or not? Just put it in the letter. Adams prosecutors, Mr. Bove and Miss Bondi, accepted the resignations of Miss Sassoon and almost a dozen other department lawyers handling or told to handle the Adams prosecution because they refused to ask a court to dismiss a well-founded indictment as part of a political deal. In her resignation letter addressed to Miss Bondi, Miss Sassoon explained that offering to drop a prosecution in exchange for a promise of assistance will violate Section 1-8.100 of the department's Justice Manual, the words of which are worth quoting here. The rule of law depends upon the even-handed administration of justice. The legal judgments of the Department of Justice must be impartial and insulated from political influence. It is imperative that the department's investigatory and prosecutorial powers be exercised free from the partisan consideration. It is a fundamental duty of every employee of the department to ensure that these principles are upheld in all of the department's legal endeavors. That'd be nice if that was actually happening right now. That'd be great. I think he asked her to put that. It could be. That could be a setup. It absolutely could have been a setup to get rid of her. I think they had a pretty good idea of who was going to comply and who was not going to comply. And so I think they could set up the people not going to comply and then terminate them. She also pointed out that threatening criminal prosecution, even to gain an advantage in civil litigation, is considered misconduct for an attorney. A prosecutor should not use improper considerations such as partisan or political or personal considerations in exercising prosecutorial discretion. That's like one of the basics in criminal law and in interviewing and interrogation. Like we all know, 2 things you can't do in the interrogation room. Just 2. You can do whatever you want in the interrogation except for 2 things. Number 1, use physical force. Number 2, make promises of leniency. All right. So just the basics, like everybody knows that. It's just, that's what the rules are. Ms. Sassoon acknowledged the zealous advocacy memorandum, but said that because she could not see any good faith basis for the proposed deal, to support it in court would violate her duty of candor under New York Rule 3.3. In Spanish. Now, Rule 3.3 we've kind of talked about before. That's the rule that is the one that's being repeatedly violated over and over and over again here. Candor towards the tribunal. So, again, in our rules here, a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. No false statements. That's in the rules. There we go. Right, we gotta follow the rules. All right, let me take a peek here. All right, I think I'm gonna have to break this live into 2, everyone. We are at our 90-minute point, and I think as we all have learned, my voice is like gonna give me a hard time if I keep going at this point. So I'll have to do a second live, follow the conclusion up tomorrow. So I will be back again then tomorrow to finish this up. But what are our initial thoughts here? What are we thinking? What about Bondi saying Luigi should get the before he was even indicted? Well, I mean, you walk a fine line. Like if you don't have any integrity or you don't really care about your reputation or value your integrity. I mean, you can say whatever you kind of want to, as long as you're careful that you don't go into defamation land. What's the tribunal definition, please? So any kind of any kind of a collection or place or moment where you have judicial authority over you. So it could be any kind of presentation. It could be an administrative proceeding. So it could be an ALJ. It could be a civil case. It could be traffic court. It could be whatever. It doesn't matter. But if someone's there that has the judicial authority over the situation, then that's what we're talking about when we say tribunal. It could be multiple judges. It could just be one. It could be a magistrate judge, whatever. But if they've got the authority to make the rulings, that's part of the tribunal. And so that candor means you have got to be honest and not make false statements to anyone with that kind of judicial authority. Does that make sense? Oh, of course, M6. Garcia was... Well, right. I mean, and that's the thing. And I've said this before, and I'll say it again. I'll keep saying it to everybody. If there's a crime, get that indictment going. Get that indictment going. If there's an indictment from a grand jury based off of probable cause, there you go. That is not a conviction. That is an indictment. And if we have an indictment, we need to go forward and figure out what's going on. Proof beyond a reasonable doubt that's been shown to a jury. Now you got something here for the books. But if we're going forward and we don't have any information, and an indictment's what we've got. Indictment's the question, right? That's the probable cause question. So again, and I always try to show the continuum, right? We have reasonable suspicion to believe criminal activity is afoot. So I'm going to do some stopping and some frisking here. Probable cause, right, is the next level. And so I'm going to be able to get a warrant with that. Or I'm going to be able to do an arrest without a warrant. If I've got probable cause, I'm going to be able to search your car if I've got some probable cause. Careful with the probable cause, everybody. Probable cause, I'm going to be able to indict you. All right. And then here, if we're in a civil case on a preponderance of the evidence, you're going to be found liable if it's 51% your fault. And then all the way over here is beyond a reasonable doubt. And that means you did it. All right. Now, I was on this live last night, and this guy, oh my gosh, this little fella was like, well, the courts are what? The higher appellate courts keep the lower courts in check. Like, that just blew my mind. Because the presumption is that the lower courts are in the trenches doing the work. And the appellate courts are like, we don't want to mess with that unless they make a clear error, clearly violate something or abuse discretion. We're not going to touch that. So the presumption is that the lower courts are doing good work. So that just blew my mind. But anyway, beyond a reasonable doubt. All right, this is where you get your verdict. Okay, so your probable cause for your indictments here, beyond a reasonable doubt's over here. All right, so I think that's important. Yeah, the discretion. And there's so much discretion that is needed to be given so that the lower courts can do their job. And I shouldn't call them lower courts. They don't like that. But you know what I'm saying, like the trial courts. All right, the trial courts. That's what I'm trying to say here. Who filed the ethics complaint? Right. And, again, when I finish part 2 here, we can go through all of the people included. But we have a couple of organizations and then attorneys here. So we have Lawyers Defending American Democracy here, Democracy Defenders, Lawyers for the Rule of Law here, and then listed out, it looks like professors. We have some professors. We have some Brooklyn Law School here. Former president of the American Bar Association. Professor of law, here. I mean, we've just got lawyers and professors and retired judges. That's a lot. Yeah, that's a lot of people on one complaint. Yeah, you're going to have to send out some serious emails to get that going. Yes, of course. So right. The point is, if there is a point, the point is, if Abrego Garcia has a grand jury indictment we've got probable cause. What do you do with probable cause? You go forward and you see what happens, right? Probable cause can be presented, does not mean that you're guilty of a crime. But the other thing too that I think is really interesting that a lot of people I think are bringing up, by the way, let me just show you real quick here in case people are looking for this case, for Abrego Garcia. This is what I found out of Nashville. I'm not sure if everyone else, if this is what you found as well, but this was the indictment for the grand jury charges that I found and the violations of federal code here, right? It's okay to go forward and have a grand jury indictment. I mean, that's fine, go for it. But, you still have to make sure you're doing your job. And it seems like a lot of people aren't doing their jobs properly with regards to this particular person. He gets indicted all the time, nothing happens. There's some kind of weird situation going on in Texas. I'm not sure why, but some weird stuff's going on down there with the Paxson. I'm not sure. As of the article from noon today, received 1,380 ethics complaints in Florida. Oh my gosh, everybody. It's been flooded. Oh no, they're going to start turning us away. It's a lot. It's really a lot. Yeah. So, I don't know the details here. I don't have the information. What I know, a grand jury's pulled in. That is an impartial body of your peers. They're shown evidence from the prosecutor. They make the decision. Is there probable cause to indict? They said yes on the points here. That's what I have. And I respect that jury's decision, the grand jury. This isn't a trial jury. This is a grand jury. And we're, again, indicting on probable cause. So we'll go forward. We'll go forward with an open mind. I've got an open mind saying, hey, what's going on? But I'm also acknowledging that this is a targeted situation where this administration screwed up pretty bad and are willing to do pretty much anything to cover mistakes and try to spin it in a way that makes them look like the hero. So, like, for example, going and saying to the El Salvador president fella, like, oh, we got an arrest warrant. Like, who cares? That doesn't matter. All you got to do is call that fella up and be like, give me the dude. And they're like, here's the dude. So, don't come in here and be like, well, we're, justice, blah, blah, blah. I'm like, no, there's no. Your client isn't Lady Justice. Your client is the Mr. Orange. And so, let's get that straight. So that kind of stuff is very suspicious. It's very fishy. It's very suspicious. We have a grand jury indictment. I respect the jury. I want to see what's going to happen, more evidence coming forward. But looking at it through the lens of reality, where we have here a group of people trying to make it out that this person's awful and they're justified in their violation of the Constitution. So how is a U.S. jury a jury of an immigrant's peers? Right. So, good question. Good question. And I use that term very in general here. Let me show you where I'm getting that language here. All right, let me just show you. Here we go. All right. For all criminal prosecutions, the accused shall enjoy a right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. So when we're talking about a speedy and public trial by an impartial jury of the state, that's the language I'm using. So when I'm saying a jury of your peers, that's just another way of saying, that there's a balance of who's involved. You're not going to be able to come in and say, well, like I've been charged as a doctor, and so I should have a jury of doctors. Or, I've been charged as an 18-year-old, so I should have a jury of just 18-year-olds. it's a very broad term, and one that was really important to have when we were dealing with things like in the Batson case, where uh, before anyone who wasn't YT male was allowed to actually serve on a jury. I mean, it's been pretty recent, actually, that women have even been allowed to serve on juries. So that's what we're talking about here. Now, citizenship versus not citizenship, that's just not a category. That's not a category that's taken into consideration, right? Because you can't serve on a jury if you're not a citizen. So that's just not even possible. Does that make sense? To bury the Elon stuff could be. It's possible. Yeah, no. Yeah. Oh, here we go. This was dated again. This is what I have found. I don't know if this is all of it, but this was May 21st of 2025. Stay decision about Supreme Court stay decision allowing Doge access to any recourse. I'm so upset. Yes, I'm going to have to take a look at that. I'm not surprised, though. I think there are multiple cases. We've got surprised though. I think there are multiple cases. We've got the veterans, we've got Social Security. The Social Security is the one that just went through, but we've got veterans information, students information, I think federal employees information. We've got a couple more suits going where all of this information is being given to Doge and it's being contested. So this is like the first of a batch. So I'm not surprised. I have not read the decision, but yeah, I'm not surprised. I would say, would you be worried about it? I guess I don't know. I have a really hard time gauging people's privacy caring, because for some things I think it's like, oh, this is our private information being given over to Doge, but then it's like you are on your phone and you just are like, hey, this is my location, this is where I'm at, this is my mom's maiden name, and this is whatever. It's hard for me to gauge that. So that right to privacy that we all have has to do with your expectation of privacy, and that's kind of weird. That's up in the air right now. I'm not a fan of Doge getting any information until it's been established that Doge has been established legally and lawfully, which has not been established, right? Because there are statutes that were jumped over when Doge was created. So I do not agree with the decision, but as far as the privacy issue stuff goes, I don't know how that's going to go. See what I'm saying? Oh yeah, no, we've got, oh my gosh, wait until the students' information comes down. Yikes. Yeah. Oh, thank you so much. I'm telling you what, everybody, I got the rainbow nails going on this month. Gotta have extra rainbows. Everybody send out the rainbow love for everybody here. For sure. Yeah. So again, it's a very interesting situation. I will be watching it. I will be watching every step of the way. I absolutely want to see what happens here with this indictment. I want to see what things are filed and how it's going. So I will absolutely be following this along with his case, his other case that's going on as well. So the magic wand pen, thank you. I have 2. I've ordered a few more. I'm very excited about them. People seem to really like them. Very talented artist made these, so it is sus. Yeah, I think it is sus. I'm not going to say that the jury's wrong or the judge is wrong in this case. I'm going to say the situation is suspicious and worth keeping an eye on. And it may very well show that there was some kind of, bad intent involved. How did they get the indictment for a year? I don't know. And as long as the statute of limitations is not run, they can go forward. But love the pens. Thanks. Yeah. Oh my gosh, I've got this really fun. Got to get the rainbows this month, right, everybody? So we got to send out as much rainbow love as possible to all of our rainbow friends and families. So we've got lots of that going on. It's hinky, Shelly. It's hinky. That is legal terminology. Absolutely hinky. Hinky situation. All right, so the wands, is this shop here on Etsy. So these pens here. Yes, here you go. Here you go. Oh my gosh, and she's amazing. She's so sweet. She's just a very sweet, incredibly talented woman. So, didn't he have a job? How is he driving people around? This is a great question, Linda. It's a great, great question. Is this a distraction to make us look away from the girls fighting? You know, I think at this point, everyone, there's just so much going on. I don't know how we could be any more distracted than we have been this entire time, right? Because it's like, is it 30 executive orders that are coming down? Is it, tariffs going back and forth? Is it like breaking down and finally following the Supreme Court order and bringing somebody back, or bringing someone back from Guatemala? You know, every single thing is a distraction at this point. So I'm not sure what it is they're trying to distract us from, because everything's awful. I guess that's how I feel. Yes, there should be a statute of limitation on trafficking. The only crime that doesn't have a statute of limitation is homicide. So 5 months of hinky. Yeah, the legitimacy of the executive orders is definitely questionable. Right. So I started at the beginning, 90 minutes ago, sorry, going through her ethics complaint here. We're going to have to do this in a two-parter because it's very long. So I made it halfway through. We'll do the second part tomorrow. How many days left until you miss your... Oh, my goodness. Yes, an essay in some states. Yes, I was shocked when that started happening. I'd love to get a list of those states. I'm going to have to do that. Thank you, Thomas. I'm going to have to make a note of that. All right, with that, my friends, I do try to keep things to 90 minutes or around in that area. So I will go ahead and let you go. I'll be back in the evening tomorrow. Wait, tomorrow's Saturday. Yep, I'll be back in the evening tomorrow. So we'll probably do 8 p.m. Central again here. We'll do another 90 minutes. We should be able to finish the rest of her ethics complaint here, and we'll keep going forward. I will take you through that indictment for Abrego Garcia and the information as it comes. So thanks for coming and hanging out with me tonight, everybody. I appreciate it so much. I will have this posted up on the Tube of You as soon as possible. So thank you, moderators, for all of your hard work. As always, I'm so grateful for your support. Take care, everyone. Have a great night. I'll be back again tomorrow.